Hello and welcome to the Trusted Podcast. I'm Blake Johnson, your host, and today we are going to be talking about business litigation. So, interesting topic. You got to, if you're a business owner, you always have that worry in the back of your head. And so I brought in a special guest today. I've got Jordan Bledsoe, and he is a business litigating attorney. So, Jordan, thanks for joining us today.
Well, thanks, Blake. I'm great. I'm thrilled to be here.
Awesome. Jordan, why don't you start off by giving us a little bit of background about yourself and then also about your firm that you're with and how you guys are really the trusted experts in your field.
Sure. So as Blake mentioned, I'm a commercial litigator. And for those of you who don't know what that is, I handle business disputes. When companies have disputes with other companies or whatever, I come in and handle that type of dispute. I handle all sorts of disputes, from breach of contract to trade secret misappropriation, false advertising, patent infringement, business torts. I mean, you name it, I've probably handled it. And so a wide range of business disputes. I also advise a lot of startup companies, and as they're getting off the ground, I advise them about things they can do to avoid litigation to make sure that their company's in the right spot to take off or eventually be acquired. My firm is Stoll Reeves. It's a Portland-based firm. It has about 350 to 375 attorneys right now, somewhere in that range. We have 7 offices throughout the country, and it's a full-service law firm. So with that many attorneys, we handle every type of dispute. And Blake, your question was, what makes us, the trusted experts in our field? And I think in large part is because we have such a large firm that any dispute that you bring to our firm, we can handle. We have expertise in just about every area of law dealing with businesses. And so companies encounter all different types of scenarios, and, we can find the right expert to put on that dispute or to help a company. And so that's really, a valuable aspect of being at the firm that I'm at for litigation and any type of business dispute or business transaction, really. So that's the basic about where I work.
Awesome. So let's dive right in. What are the biggest mistakes that you see business owners make in regards to causing litigation to actually need to happen, or that result in losses when they do get sued?
Right. I mean, that's a great question. Every business wants to avoid litigation. It's expensive. It's a pain. It's a drain on resources, time, and a lot of times it's emotional. It's an emotional drain. And so what I'm going to tell, the things that companies can do to avoid litigation applies not only to startups, but really seasoned businesses. We see these disputes crop up in all types of businesses. And so there's 5 areas that I've really seen where businesses can take steps to shore up what they're doing to avoid litigation. And the first and most important is making sure they have well-done contracts that are essential to the company's business. And so not all contracts are equal. And we're talking about contracts that are really essential to the company's business. So let's take Apple, for example. Their contracts with suppliers to make sure they're getting products on time, components on time, are going to be essential. Likewise, their contracts for the components. They want to make sure the components work. Those are going to be the types of essential contracts. Now, I'll give you an example to illustrate what I'm talking about. So we represented a startup company, and they came to us after the dispute had already started, but I'll go back in time and tell you what happened. So the company had a great idea for this app, and they said, look, they got an initial round of funding, and they said, we're going to use that funding to hire the best company we can to build this app for us. So they went to a company out of San Francisco who had built apps for some major companies and hired them. Well, they didn't have an attorney representing them. They took the contract that app builder company gave them, took a quick look at it, and said, this looks great. We trust them. They've done work for big companies. It's all going to be great. The app was supposed to be done in a year and a half, and it was going to cost them around $250,000. Well, we got a phone call after about 10 months into the project. The app was only 25% done, and they had spent several $100,000 already. And this app company, the one developing the app, they kept coming back to our startup company saying, look, we need more money, and we're just not going to be able to get this done on time. And it got to the point where it looked like the app to build it all was going to be more than the company could afford, and it was going to take longer than really they could handle with the funding they'd received. And so they had to pull out of the deal and cut their losses and go with a new developing company. And they were out a lot of money and a lot of time. And they came to us at that point and they said, what's our remedy? What can we do to hold this company accountable? And we looked at the contract that they signed, and as you would expect, the contract was terrible for them. The company building the app had made the contract very favorable to it. And so companies that try to sue it really had a hard time having any good remedies, because there was a lot of provisions in there that gave them a lot of leeway in terms of timing and pricing, that if they would have approached an attorney when they were reviewing that contract, the attorney could have come in and helped them negotiate for a much better deal. But because of that, they were in a big mess and ended up, incurring a big loss, which was unfortunate. So, number one, contracts that are essential to the company's business. Number two is documents to protect intellectual property. I mean, these are essential. We're talking about patents, protecting your trade secrets, copyrights, things of that nature. I think that those are, people generally understand that. Employment documents, I think those are very important. We had a dispute where a friend hired a friend and didn't have good employment documents. And when the relationship broke down a year and a half later, the documents weren't written well. And so one of the individuals had to pay his friend and former business partner a lot of money to settle. And all of that could have been avoided if he had, written the contract out and had an attorney come in and help him. The fourth category is business formation documents. And with this, we're talking about articles of incorporation, operating agreements, bylaws. And those might seem like really basic documents, but I've seen many disputes arise when those just aren't done well and an attorney doesn't draft them. People just say, look, I'll pull something off the internet, and don't have it drafted well, and then it leads to disputes later on that cost a lot of money and take a lot of time.
Yeah, it's interesting because whenever you start a business, people they always think, oh, it's going to go great, and they only think about the good side of things. They don't think about the bad sides. What's going to happen when me and my business partner can't come to an agreement on something? What happens when one of them wants to leave after 3 years? Those kind of issues. I see that all the time. Because I help do those drafting, those initial documents, and it's like, guys, no, you got to think about worst case scenarios, because you're all friends now. It's a lot easier to agree now than it is going to be when you're all fighting and hate each other.
No, you hit the nail on the head. That's exactly right. People, when they're starting these companies, they think that it's going to be great and they're not going to have these disputes arise, especially if they're working with their friends. But like you said, all too often, things start to fall apart, and if they don't have those agreements drafted by an attorney and drafted well, it prevents a lot of disputes. And I like what you said. You said planning for the worst case scenario. I think that's exactly what you want to do, is plan, okay, look, we all get along, we all like each other, but what happens if things really fall apart? Worst case scenario, what provisions do we need to have in place that will help us figure things out in that case?
And I think it helps prevent a lot of fights, because it sets the expectation ahead of time. Hey, here's what we already agreed to, and here's what's going to happen if I do X or Y. So I think it just in that regard, because you've already thought through it and everybody's already talked about it, it does help prevent any fights, or a lot more fights from happening. Yeah,
no, you're exactly right. So the fifth category is non-disclosure agreements. Often you'll have companies, you'll hire someone or you'll want them to look at your intellectual property, and those non-disclosure agreements need to be buttoned up so that you don't have a former employee leaving and sharing trade secrets or how you're running your business, or someone, reviewing your technology and then saying, hey, I think I could go do this better. You need to have those done really well so that if somebody does that, you have a strong remedy and can either prevent them from doing that, or if they do share that confidential information, you have a remedy to go after them.
Yep, I think those are all big mistakes. I think that's great. So what things can owners do other than hiring, an attorney to draft everything? We know that gets expensive. So what things can they do on their own, and when should they actually get the attorney involved?
Great question. A lot of things businesses can do on their own, and non-essential contracts is one. Contracts that aren't really essential to their business, they don't have to be perfect. They don't need to account for the worst case scenario. And I'm thinking, there's a handful of documents that you could pull off the internet, terms and conditions, or whatever it may be for your business. Every business is different, but contracts you think, look, these aren't really essential. And I'll often have startup companies who are on tight budgets come to me and say, hey, could you send us some template agreements? We want to hire this person, an at-will employee. Do you have a basic offer letter template you could send us? And I said, yeah, happy to do that. It takes me 15 minutes. Often I don't even charge them for it. And then they can fill in all the blanks and draft them themselves. And usually I'll tell them, yeah, look, I'm happy. You don't need an attorney to draft this necessarily. In a lot of situations you don't. And so people can do that on the cheap. I think another thing is businesses, a lot of times they can resolve disputes by themselves. I represented a company that built fire trucks, and a company did a lot of work they did a lot of work for a company, and the company didn't want to pay them. And so the owner called me up and said, hey, what should we do? And I think the common response of litigators may be, well, let me write a letter, and and then we'll send them a demand letter, and if they don't, respond to the demand letter, we'll file a lawsuit. But this, where it was, a few tens of thousands of dollars, it wasn't worth it to go to litigation over this. And so I talked through them. I said, look, why don't you approach them and propose a business resolution? And we talked through how he should approach the phone call, how he should handle concerns. That afternoon, he went and called the company that owed his company money. They had a nice long conversation and resolved the dispute without involving me, other than a 30-minute phone call. And so a lot of times, if it's small dollar amounts, companies can resolve their own disputes. It helps to have an attorney that they can go to say, hey, how should I address this problem? Do I have a strong legal position here? And often I'll say, yeah, you do have a strong legal position. Let me give you some information about that. That will give you a good negotiating position when you approach this company about, paying you for the work you've done or whatever the dispute may be. So not every problem requires an attorney, although it is great to have an advisor to consult with, to say, hey, how should I handle this? Or even to bounce ideas off of. And so, one thing I love about my job is helping companies solve their own problems. And if you get a good attorney, the right attorney who you really trust, who's interested in your business, they'll help you solve your own problems. And one thing I often hear from business owners is they say, look, I'll go to my attorney and I'll say, hey, can you answer this question for me? And they say, I really just want, a 2-minute, what's the bottom line answer? But instead I get a $10,000 memo fleshing out every possible scenario, when really I didn't care about that. And to me, I think, well, that's just a problem. There's a breakdown of communication either on your end or your attorney's end. That shouldn't be happening. A lot of times, the answer is short, doesn't take a lot of money, but I think that's what creates a lot of concern for companies. They say, attorneys are expensive. No matter what we do, it's going to be $5,000 here, $5,000 there. But that's just not true. If you find the right attorney, they'll partner with you in your business and help you solve your problems on your own. And then problems the company can't solve on their own, the right attorney can come in and help out. But that's what I think of an ideal attorney, of someone who knows the business, knows the client's needs, and knows when they can solve their own problems.
I really like that, because I think litigators especially get the rap of being bulldogs and just want to fight everything and be involved in everything and kind of be control freaks on that. But one of the things I try to do when I find trusted people is find people who are willing to communicate, who are going to explain and provide information as far as what to do and help them do stuff, give them tools so they can do stuff on their own. and then you're there in an advisory capacity or in worst case scenario. So I really appreciate that, because there's not very many attorneys that I've run into that think that way. It's, because everything's billable hours, that's how they make their money. I've got to try and make this a bigger issue than it is, instead of taking the approach of, hey, if I build this relationship and give them the tools to succeed when there is that big problem, they're going to trust my judgment and let me really go after it. So I think that is very key for anyone looking at a business attorney. They got to find someone who's trustworthy, who's actually going to have their best interest at heart, and give them the advice they need, and not bill them exorbitant amount of fees, because it doesn't need to be that way every time.
Yeah, I totally agree.
Okay, so let's switch gears a little bit. When, let's say somebody gets sued, a business gets sued, at what point do they need to call the attorney? Let's say they get the demand letter initially. Do they need to call the attorney then, or do they wait till they actually get served court papers?
Now, another great question, and I'll say I think they should approach an attorney as soon as they have an idea that a dispute may be bubbling, before, if possible, even before a demand letter, but absolutely before a lawsuit is filed. And let me explain why. I'll start out with a story, and then I'll get into some details of why it's important to approach attorneys early on. So recently, I had a client contact me, and he was one of two owners of a mobile home park. And he said, look, my sister's trying to sell this mobile home park. I don't want to sell it. And the park was going to be sold for a lot of money. And so he got me involved, and we looked at the documents, determined, okay, what can you do to prevent the sale? Can you prevent the sale? And long story short, it turned out to be an absolute mess. The company buying the land was going to file a lawsuit. The sister who wanted to sell the land, it was probably going to end up in litigation with her. And my client wanted to sue everybody. And I sat him down and said, okay, well, let's talk about what the best solution is here. Do we file a lawsuit, or what do we do? And we sat down, I did research, looked at all the possible solutions and presented them to them. And we decided, hey, let's try to resolve this before filing a lawsuit. And we did what's called mediation. You know what that is, Blake. But for those who don't, it's where you get together and you have, a former judge or an older attorney evaluate the parties' positions and tell them how he thinks it would probably resolve in court, and what he thinks are the strengths and weaknesses of each party's case. So we mediated that, and it ended up being there was 5 or 6 parties involved in this mediation, and we ended up completely resolving the dispute before any litigation was filed. My client was really happy with the result. The company purchasing the land was happy with the result, and so was everybody. We were able to reach a great resolution. I think if this went to litigation, it probably would have been several $100,000 and may not have turned out well for my client, and likely wouldn't have been as good of a resolution as we were able to reach before litigation. And so there's times to file litigation, but there's times where it can be resolved, before that. And so approaching an attorney early on can sometimes save you a lot of, pain, money, and time if you get them before it actually turns into a dispute filed in court. Now, sometimes you can't do that, and that's, Blake, that's what you're referring to. Sometimes you get a demand letter saying, hey, pay us this money, you owe us this money, or we want you to do this. And it's important to get an attorney involved right away. Part of it is so you can create good evidence. I'll tell you these quotes, and I kid you not, of cases when we were brought in too late, and the client sent emails in the company or to each other, and these are some of the quotes. I'm not a lawyer, but I think we breached the contract. We may get sued for this. Another one said, could I go to jail for this? One of the bad ones was, hey, here's the plan to screw one of our partners. And another one is, can we disguise this so that the government doesn't find out what we are doing? These are quotes from emails that were sent within the company, just because people they weren't thinking, hey, this is all going to be discoverable. This is all going to come out in the lawsuit. When in fact it is. That in discovery, which that's what it's called, you have to give all the documents that relate to the lawsuit, and the other side has to give them to you. And so if you get an attorney in there early on, he can make sure that people aren't saying stupid stuff, and he can make sure that he's part of those communications so that they're privileged, so they can't be disclosed. They don't have to be disclosed in the case. And that's a huge mistake we see all the time, is they involve attorneys too late after they've said dumb things, and it turns out to really bite them when a case gets filed. So creating good evidence is a big one, and also positioning yourself in the litigation. You know, how do you respond to the demand letter? Do you say, hey, yeah, we agree, we owe you some money? Or do you take a hard position and say, no, we're disputing this for these reasons? I mean, I could go on and on, but I'll just leave it there. I think involve an attorney as early as possible is always in the company's best interest. And like I said, maybe it doesn't mean the attorney does a lot of work, but at least advises the company about steps they can take to make sure that if it does turn into litigation, they're in a very good and strong position.
Yeah, it's interesting what people will say in email. If you're going to say anything questionable, don't put it in writing. Say it over the phone at least, so it's not, and make sure it's not being recorded. So that's
yes.
an interesting thing.
Yes.
Give me your top 2 ways of, creating good documentation or evidence that business owners should have, in case of a lawsuit.
Well, I'll go back to the one you said. I just want to reiterate: get on the phone. When you have something in your company, a dispute, get on the phone. Don't shoot a text message or an email if it's about something sensitive. So it's as important to avoid bad evidence as it is to keep good evidence. And so keeping all of the documents that you have, keeping emails, keeping good records, receipts, contracts, everything. I keep everything so that when you do get so if there is a dispute, you have records of all your conversations with the person whom you claim owes you money, or who you may be suing, or who may be suing you. I think that's really critical that companies keep all their documents, and hopefully in an organized fashion. So obviously that's very important, is documentation and making sure that you have records so that when the time comes, if you need to prove your case and show the other company owes you money or breached a contract or something like that, you're able to do that.
How long should they keep those records? Is it forever? Is it 5 years? What's a good rule of thumb?
No, that's an interesting question. There's statutes of limitation, and the statutes usually bar claims after a certain amount of years. In Utah, for written contracts, it's 6 years. So any documents relating to contracts, I'd keep for at least 6 years. And I think companies should just use good judgment. I keep things for at least a few years. I understand it can be more expensive, to keep a lot of documents, but ones that are again essential to the business, hold on to those as long as possible, I would say. And if you have an attorney, ask them, say, hey, we have these type of business records. How long should we hold on to those? I mean, so our firm represented a company that had traffic light recordings, and it approached us and said, how long should we hold on to these? And so we went and found the statutes of limitations for every state in which they had these traffic cameras and said, okay, here's the dates that you should keep all of these. And really, I mean, that's something they couldn't figure out themselves, and we gave them, all the information they need to protect themselves if there was some lawsuit over these camera recordings. We made sure that they didn't hold on to them longer than they had to and incur that expense, but also they held on to them long enough that they'd avoid any issues if there was a dispute over any of these recordings.
Perfect. Yeah. It's a favorite attorney answer, right? It depends.
Yeah.
All right. So how can our listeners find a good, trusted business attorney like yourself? What should they look for, and any red flags that they should for sure stay away from?
Sure. I think there's a lot of really great attorneys out there, but there's also a lot of not great attorneys out there. And I think I'm going to categorize them into 2 types, even though there's a lot of different ones. So the first type, which I think is an ideal attorney, is someone who really cares about their clients, who's a good communicator and who's upfront about, fees and costs, and communicates clearly with his clients. But at the end, it's someone who really cares. And attorneys like this generally do what's in they're supposed to do what's in their client's best interest, but in terms of billing, they help the client solve all the problems that they can. Their goal isn't to rack up fees or, bill a ton of hours. It's, hey, how can I best solve this business's problems? What's the most efficient way to do this? And attorneys like that seem to have repeat customers again and again because the clients realize, hey, this attorney really cares about our company. He's helping us save costs where he can, and only when we really need him to dig in, will he start charging hours, and he'll let us know, hey, it's up to you, but this is what it will cost. Is that an expense you want to incur? You hear horror stories about companies who hire an attorney who isn't upfront with them about how something is going to cost, and then they get these massive bills that they're like, hey, we never agreed to this. We didn't want you to do this work. We didn't need you to do it. And it just turns out to be a nightmare relationship. And generally those attorneys have one-time clients. Not often do they have repeat clients. So if I could boil that down, I'd say find an attorney you really trust. Plain and simple. Find an attorney who really is interested in your business, wants to get to know it, who understands, what your business needs, what you can afford, to really how he can best help your business, and someone who knows it inside and out and is interested in learning about it. And finally, an attorney who can help you find your own solutions to problems and who can help you avoid problems. And then lastly, I guess to add another point, someone who communicates openly, who's upfront about fees, how much things will cost. One thing I often say is, look, if a client calls me for a 5-minute call and has a quick question, I'm not going to charge them. I'm here to help them out. I'm not going to nickel and dime them. And I feel like if I do that and, I really show them that I care about them and I'm more than fair with them with fees and time, that pays back tenfold, because when a big dispute arises, they trust me and know that I'm going to be cost sensitive and do what's in their best interest.
Yeah, I think it's interesting that you said that, because there's clients can always contest your hourly rate or how you spent your time and say, oh no, this wasn't it. Like, especially if you're dealing with insurance companies, they're gonna say, oh no, you didn't do this, we're not paying for this, whatever the case is. Whereas if you have those clients where you say, they know, hey, the guy doesn't nickel and dime me, they're gonna get the bill, they're just gonna pay it on time, and it actually saves you more time down the road. So I really like that. Last thing I want to add is, go check and make sure there's no claims against that individual, that attorney, with the state bar. If you just go search, the Utah State Bar, the Nevada State Bar, you search the attorney by name, it'll see if they've had any, claims filed, if there's been any action by the courts against them. So that's an easy way to see if someone's not a good fit. And then outside of that, ask other business owners. Usually within your industry, there's guys that are good. Obviously, you don't want your competitor's attorney, because if you ever have a dispute, that's a different issue. But there's usually, people who know who's good and who isn't. And then lastly is your gut. If you're not going to get along with them, or if they're not returning your phone calls to get you as a client, how do you think it's going to be when you've already paid them? So don't, if it's bad from the beginning, it's only going to get worse.
Yeah, I agree. And don't be afraid to meet with several attorneys. We have that where a sophisticated client will say, hey, can I meet with you? And it's just an initial consultation. I never charge anything for those, and I think a lot of attorneys don't. We'll sit down and say, hey, here's how I would solve this issue. And then we'll go meet with someone else, and they'll meet with a few. And then after that, they usually have a good sense of, hey, who's the person that I can see myself working really well with. Generally, that's for larger disputes and more sophisticated companies, but I think that's a good idea for someone who's looking to have a long-term attorney to hire for their company.
Yeah, I don't think it ever hurts to meet with multiple people, just because you can get a sense of who you actually like and get along with, because that's a big part of it. Is, who do you know you look forward to talking to, or if you need to, and you're not intimidated by them. I think that's definitely part of it. So, anything else that we missed that you think is vitally important for business owners to know about litigation or how to avoid it?
No, I really don't think there's much to add. I'll just summarize real quick what we've talked about. And I think first, find a lawyer you trust, and don't worry about just picking up the phone to seek advice from your attorney and having them help you solve your own problems. Two, make sure you involve an attorney for all your really essential documents. That's going to pay dividends time and again over the long run. And then finally, call litigator as early as possible. As soon as there's a possibility of a dispute, get in contact with them, get some advice about how you should proceed, what things you should avoid or what things you should proactively be doing. That, again, will save you in the long run.
Perfect. Well summed up. To our listeners, hopefully you got something out of this. Please like and subscribe if you haven't already. And then, let us know how we're doing. Leave us a review, and then that way we can make sure we're always getting better. And if you have ideas for who we should have on the show next time, please contact me so we can get it done. Jordan, last thing is, if somebody wants to get in touch with you, how can they do that? How can they find you?
It's easy. You can search my name on Google, and I'm the first person that shows up. It shows commercial litigator. So it's just Jordan Bledsoe, Bledsoe.
Perfect. And I'll put a link to the firm website and his office number in the show notes. That way you can have it there. And with that, thank you, Jordan, for joining us today.
Thanks, Blake. It was a pleasure.
All right. We'll talk to you guys next time.